Hey everyone, thanks for joining me. I don't take it lightly that you gave your time for this event. Your time is valuable and it's the one thing that you can never get back. And so if someone demands my time, I expect them to deliver. And so I hope that I deliver for you today. I'm Brian T. Bradley. I'm a licensed attorney in multiple states and focus exclusively on asset protection for investors, high-risk professionals, entrepreneurs, and high net worth affluent families. I am the senior managing partner of Bradley Legal Corp. I am also of counsel of Laudmo and Laudmo, the leading expert in advanced asset protection and strategic planning, and an advisory board member of the Asset Protection Council. Collectively, we have over 3,000 clients nationally in every state and are protecting over 5 billion worth of assets. And so just some more about who we are. I was selected to America's Best Attorney List 2020, the top 100 high-stake litigators list, Super Lawyers Rising Star 2020 and 2015, the Lawyers of Distinction 3 years in a row, top 100 in real estate. This is my partner, Douglas Laudmill, who is a leader in asset protection and actually created the breakthrough revolutionary concept of the bridge trust. My hope is that the key concepts that I talk about today will help all of you to better plan and take the preventative steps to protect yourselves. And now I'm going to talk about asset protection, and I'm going to be bursting a lot of the misconceptions today. And that's the big value that you're going to be getting. Just a very deep understanding of asset protection, how to properly layer it, and how to scale your planning as you grow. And feel free to use the chat to ask questions or hit the raise your hand button. Don't worry about if you have any noise in the background, like kids screaming and crying or the TV or phone calls ringing. I have everybody on automatic mute. And so if you have a question I think is pertinent to the topic we're at, I'll unmute you and you can ask your questions. And if I can get to them, as I go along, I will. But also remember that most of your questions will probably get answered at some point in this presentation. And then at the end of the presentation, I'll see what time we have left to answer more, if any are needed. And now I talk a lot on investment shows, and the constant takeaway really is that as investors, you're so focused on growing and adding to your portfolio and raising capital, closing deals, return on investments, analyzing metrics, but you don't think about what's needed to get done to properly protect those assets, and you don't look at the liability and legal risk and how you can lose it generally until it's too late. Most don't even understand how they can lose their investments or where their liability and risk, even are with their businesses and in your personal lives and assets. When you get sued, you generally don't see it coming and have most of your assets held in the I don't know what I don't know side of the pie chart. And that's just dangerous. That's what this talk is about today. The different layers and tools and strategies that exist to protect what you have built and are in the process of building, as well as the macro and micro views. And we're really just living in fascinating times right now. We're seeing laws and policies drastically change every day, and people getting sued and being sued that normally wouldn't be getting sued. So protecting your assets, your wealth, and your legacy is more important now than ever. We have over 40 million lawsuits filed in the US each year. Plaintiff attorneys are constantly advertising for new targets, meaning you. The claims, by former employees, along with employment law claims, harassment, discrimination, and wage and hour claims are just skyrocketing. The US legal fees exceed over 300 billion annually now. And insurance companies are constantly denying claims now, and they want your premiums, but don't want you, to pay you when you need them. So, let's start with just the very basics, just like the sound of music, do, re, mi. I am teaching my 5 and 4-year-old daughters to play the piano, and there are thousands of songs that you can play by learning just 3 basic notes, C, D, and E. And we also want to start here at the very beginning when it comes to asset protection. So let's just start with defining it. What is asset protection and what are the key goals? And so asset protection is simply creating a legal barrier between you and your assets. It's really that simple. It's like a safe that you want to put your valuables like your guns and jewelry, watches, and gold, all tucked away safely in that safe. I'm a big believer in the Tony Robbins principle that success leaves clues. And if you want to be rich, mimic the rich. Just like the rich, we want you to have the benefit, the use, and the enjoyment of what you own while separating out the liability side of it. Rich people, they don't own things personally. They just use them, they enjoy them, and they benefit from them. We want you to be able to go out and use your boat or plane or car, enjoy it, rent out those properties, build your portfolio, but you just don't want to own it personally. Instead, your asset protection trust and business entity owns it. The role of asset protection is simple. It's peace of mind and lifestyle preservation. When a client calls and is asking for asset protection, that's really what they're saying. Hey, I want to sleep well at night. You want less stress knowing your finances and your assets are safe. Nobody wants fear paralyzing them. You want to keep what you have and what you've worked so hard to build. Asset protection planning is your modern best bet to level the playing field against this out of control legal system. And we do this by using all of the different legal tools we have, LLCs, limited partnerships, and asset protection trust. And what this does when it's done right is that it makes it very hard for creditors to collect on you. And what we are concerned about really is just collectability. And now you might be asking like, okay, Brian, so what's up with the legal system? What's changed? Well, a heck of a lot's changed over the last 40 years. It's no longer about justice, but redistributing your wealth from the haves, which is you, to the have-nots. Now, for people who grew up with a more old school mindset where lawsuits really were never an issue, back about 40 years ago, you could essentially have everything in your own personal name or in a family trust. That was acceptable then, and you can get away with that 30 or more years ago. But over the past 40 years, the litigation landscape has just completely changed. Things that just didn't happen in the past or that weren't allowed to happen in the past, like contingency fee lawyers or law firm advertising, are commonplace. And this created law firms that are purely sales and profit driven, representing clients with no skin in the game and nothing to lose. And the US doesn't have a if you lose, you pay system like other countries. And so we have plaintiffs simply looking for a target to get a big payday out of in a legal system that's not looking out for you. And then we also have our own false sense of security. And I see that, what is contributing to this false security comes from people thinking that they don't need to do anything and just ride lady luck. But that's not a plan. That's just gambling and wishful thinking. Or they think that their insurance or umbrella policy will always cover them, which it won't. It's important to have, and you need insurance, and you need good insurance. But we're getting more and more clients with claims that are radically in excess of their insurance coverage. So being underinsured is a big problem. And insurance just provides capital to fight. Or your insurance provider does what insurance companies do. They create legal wiggle room through claims of intentional acts and wrongdoings, and then they tell you that they're not going to be covering you. And if you think that they're wrong, well, go ahead and sue us. So now you're left with, 2 lawsuits, suing your insurance provider while also being sued. And a few examples here are, we have a California resident who's a client, who's a doctor, who purchased a property in New Jersey. He rented out the property to, unbeknown to a gang member. The gang member had a party at the property. A fight broke out, guns were pulled, somebody was shot and killed. Who's the one being sued civilly for wrongful death and negligence? The owner of the property, the California doctor. Also, there's a recent case that came down in Louisiana just a little bit ago with an owner of an Airbnb, a short-term rental, rented it out short-term to a guy who started drinking all day long, got very drunk, pounding bottles of whiskey, decided to do what drunks do, and ran out the back patio about 2 a.m, did a head dive into a shallow pond on the property, landed on his neck, broke his neck, became a paraplegic, and then sued the owner of the Airbnb and just got awarded an $11 million judgment against him. And so then mold claims also tend to turn into multi-million-dollar lawsuits, especially if somebody gets sick or deals falling apart if you're now sponsoring deals. And I'm going to get more into case studies later on at the end of the 1 hour mark, but you kind of get the idea. And then when we get into the world of high net worth and affluent families and wealth, at this level, we now have to deal with microeconomic global issues. The big picture really is that we have a global financial system that has structural, deep-rooted issues, along with government-backed fiat currencies that are now in question. And this includes the US dollar. The US dollar is no longer exempt. The monetary policy today is just very plain and simple: inflate or die. And with governments looking for deep and accessible pools of financing, meaning your money and your assets, and then we have financial repression, monetary economic manipulation. It's just adding more challenges to protect and preserve your wealth. This is where a full and diversified asset protection plan really comes into play. And so it really just begs the question, in this present hyper litigious climate and global chaos, how confident are you that you're not going to be sued? And how confident are you that if and when you are sued, the legal system will actually treat you fairly? How many people can confidently raise your hand and say that you have the current planning and system in place that will protect you? And so asset protection is your modern best bet to level the playing field against these modern wealth destroyers. We're no longer talking about death taxes destroying family wealth, but predatory lawsuits, a broken system, divorce, out of control medical costs. These are your modern day wealth destroyers. And then by using all the different legal tools that we have, what this does is it makes it very hard for creditors to collect on you. And when your planning is done properly, and when it's seen as being effective and impenetrable, this then puts you in a lot stronger position at the negotiating table. In fact, it chases most people away. We have a saying that you want to make yourself look as ugly as possible to a potential creditor, but it's kind of contrary to human nature, where we want to be people pleasers. I can't stop you from being sued. Nobody can. That just comes as a byproduct of success and increasing your visibility and your holdings as you grow. But we can help with how collectible you are. This then puts you in a position of strength and gives you more legal leverage. The result of this is that you're going to radically deter the majority of those predators. And if you do get attacked or sued, you now have the proper tools and system in place beforehand by being proactive to successfully protecting your assets. But this all has to be set up beforehand. That's the big key word: before it's needed. If you do, then you're going to end up being happier, less stressed, and more productive, since you'll have less fear about conducting your businesses or hiring, firing workers, contracting, investing, adding to your portfolios, syndicating deals, and even just sending off your kids to drive your cars. You'll just have more peace of mind about your financial security. And now, for all this to work, 4 things have to be true. Your system must be seen as impenetrable. It must be managed properly. The plan cannot attract a lawyer wanting to challenge it, thinking that they're going to get a payday, and it must work. So as a client, we then know that you want 4 things. You want an effective plan. You want to control your plan. You want reasonable and sustainable cost. And you want a plan that's easy to maintain compliance on. And so here's where we're going to go. I'm going to break down the tools that we use to accomplish all of this, and then I'm going to put it all back together again. And so we have the LLC, the limited liability company, the AMLP, which is an asset management limited partnership, and asset protection trust or bridge trust. And so let's break these tools down. When it comes to asset protection, we have different layers. I'm from the mountains in Lake Tahoe. We get lots of snow. I also lived in Michigan. It's freezing cold there, and in Oregon with cold dampness. So obviously we learn to dress in layers. The first layer is your base layer. It's generally made from merino wool, and it sits on your skin. This is your LLC. And then we want a mid layer, which is usually a little bit thicker, and it can be synthetics or wool, or for you ladies, a cardigan. This would be your limited partnership. And then you want an outer shell waterproof layer. This keeps you nice and dry and warm when the weather is really cold and bad. This is your asset protection trust. But by layering, you're now more flexible. When it gets hot and you're skiing or ice fishing, you can take the outer layer off, or the inner layer off, or the middle layer. You can adjust to make yourself more comfortable. The same thing applies with your asset protection plan. The base layer is your LLC. It's going to be holding your real estate. So let's just start with the LLC. The LLC is a great first layer, and it's the entry place to start. It's the foundation along with insurance. LLCs are great holding companies. We place things in them that have keys, or it can go boom, things that can hurt people, and things that you need to get liability insurance for. You can place all your risky assets into an LLC, but you want to separate asset holdings from operations and operate your business dealings out of another LLC called an operating company. So if you're considering just this first entry level protection, maybe you're just starting out investing, your net worth is under 500,000 and you only have 0 to 1 to 2 units. You should consider at minimum setting up 2 LLCs. But by using LLCs, what you're doing is limiting some of your personal liability and separating ownership, use, and control. If you're trying to protect, again, just a few assets and money's limited right now for you, the LLC and insurance is a great place to start. Now, obviously everything has kryptonite, and if you talk to Superman, kryptonite is no good. The LLCs lack on efficiency. Just remember that, they're called what's maybe protection. And it's, it says it straight up in their name, first letter, first word, limited. They don't hide that fact. And we have decades of case law that exists around this fact. This is the term piercing the corporate veil, meaning holding you personally liable. Now, this is where I'm going to spend time talking about the negatives that you're not told about LLCs, so that you then understand the limitations and then the need to layer as you grow, because where you start is not where you're going to be ending. Now, the problem generally is that most clients come to me with 15 LLCs, and they're all single member LLCs, and they're all disregarded entities and all in the client's personal name as the member. Now we have a problem from an asset protection standpoint, because the courts have a tendency to disregard those single member LLCs held by individuals, meaning you. And then CPAs tend to set up LLCs as disregarded entities for tax purposes. That's great for taxes, but is horrible and bad for lawsuits. Or they set up S corps for real estate, and that's another bad thing to do, to be doing, because S corps have shares. One reason for this is, for example, those shares can be frozen by a judge. And I actually get this a lot. If you come to me with, real estate in an S corp, and let's say you have $100 million worth of real estate, all within one S corp, or it can be other assets like trucks. Like I have a trucking company with millions of dollars worth of assets in flatbed trucks. From a liability and asset protection standpoint, it's not good. We prefer to move those assets out of the S corp, but we wouldn't want to do that at this point without having to have you pay a huge tax recapture fee to the IRS. So now we're stuck. And this could have all been avoided if the planning was set up properly from the beginning to grow with, possibly by having the client and the CPA and the asset protection attorney all on the phone and talking together, and then separating the assets out of the S corp and owned by a different LLC, and then just operating out of the S corp for tax purposes, all at the beginning of the business venture. But to get back to being disregarded, what an LLC being disregarded means is that the IRS is not taxing your business separate from you. It passes through to you personally. And because of this, they're basically worthless for asset protection and liability issues, because that liability also passes directly through to you. But don't get me wrong, I still use them, but as a base layer entry protection. Then we build and layer strength above that. What you actually want is for that single member LLC that's holding your real estate to then be owned not by you, the individual, but by a second layer of protection, which should be a multi-member limited partnership, not an LLC. And I'm going to break down the benefits of the limited partnership later. But by doing this, what you're now doing is properly layering your protection. Your mid-layer, the limited partnership, will be owning all those LLCs that are holding your real estate. And so all those LLC tax filings and K1s will simply passively flow directly through to the management company. So you'll just have one tax filing. What we're doing is maintaining the legal protection, but we're disregarding them for tax purposes, creating a very smooth and easy transition for fewer tax returns by adding that second layer, the limited partnership. It really just comes down to how you use them all together. And the second big misconception people have with LLCs is, where do you even go to set these LLCs up in? Like, do you go to Delaware, Wyoming, Texas, Nevada? This is kind of like charging order chasing, and you hear about these states, and some of those states have privacy. And so people are like, oh, I'm just going to go and do that. Well, in reality, it really comes down to an issue of just what are you holding and where are you holding it at? So let's say, for example, it's California real estate, and you set up a Wyoming LLC, and then you bring it to California by holding a key piece of California real estate in it. and you're also paying California franchise tax because you're a resident of California. What you've done is just convert your Wyoming LLC to a California LLC because you're doing business in the state of California. And not only are you going to pay the franchise tax, but if you ever have a liability issue in California and and you get sued, the judge in California is going to apply which law? California law, right? Not Wyoming or Delaware law. A judge in California or any other state doesn't care that your LLC is a Wyoming LLC. What they care is that it's doing business in California or whatever other state it is. The same principle applies if you're a resident of other state or the asset is held in another state. That's the state the asset is in. That's the state the injury or damage occurred in. It's going to be that state's laws that apply. You can't just take another state's laws and transfer it over there. Just by simply owning an out-of-state LLC, you have to legally register that LLC as doing business in the other state that you live in. So you'd have to register it in California if you're a California resident, or Oregon if you're an Oregon resident, Washington, Florida. This is just basic law. And once you do that, you did this fancy legal word called availed yourself of the privileges and laws of that state and given that state jurisdiction over your out-of-state LLC. And then we have this great case, Indian Palms Country Club Association versus Anchor Bank in 2015. This case lays out all the multiple legal standards you're going to have to meet to successfully beat a piercing the corporate veil argument and jurisdictional elements. Like, you wouldn't meet any of these as legal standards as a real estate investor, just because real estate is different. Then it's just a matter of applying basic corporate veil piercing strategies. And at that point, all your assets and you are now personally on the hook. So for assets that are real estate, remember, real estate is just different. And I recommend using the state that the real estate is located in, because you're not gaining anything by using another state. You're just doubling your maintenance costs. So just keep it simple and properly layer. And then we have another big misconception when it comes to how and when to use series LLCs. They're very young with no case law to rely on, and only a few states actually have series LLC statutes. What this means is that if you live in a state that does not accept series LLCs and does not have series LLC legislation, like California, like all the West Coast and most of the other states, East Coast, and you purchase real estate in a different state and one of those states does not recognize that structure, you won't get the benefit of them. And they're still only as strong as a traditional LLC, because that's what they are, an LLC. They just have another element of being able to create sub-children layers underneath that parent structure, but not all states allow this. Now, I like series LLCs, but only for individuals who live in a state that has series LLC statutes and the asset itself is in a series LLC state, and again, only as a base level layer of protection. And then we get to the final big misconception of LLCs, and that's this really new fancy word called anonymity that everybody's falling in love with. And the thought here is that you can just create an anonymous Wyoming LLC and you can just poof, disappear and can never be found. That the LLC member's name is not available to the public and you can just completely avoid and ghost the lawsuits. This is just completely false. Wyoming LLCs have their place in asset protection and in the asset protection world as a first line of defense for business owners for privacy, and not placing yourself at risk of harm for harassment or someone finding out where you live and hating you and going to egg your house. But it's a privacy mechanism before lawsuits start. But this does not mean that your identity can't be found, or that when your LLC is sued, that you won't be legally required to appear and defend yourself or, and your LLC. Wyoming and Delaware LLCs, and all out-of-state LLCs like Washington, if you were not a Washington resident and you created a Washington LLC, require personal agents of service. Their sole job is to serve you and tell you, hey, guess what? Congratulations, you just got sued, now go defend yourself. And you're legally required to have one of these, otherwise you didn't properly create that LLC. Then the lawsuit will be simply amended and you're going to be named personally. The simple reality is that once a lawsuit is filed, the discovery process of litigation begins and you will be served and then you will be subpoenaed and forced into court. And then what's even worse is that if you want secrecy to even work, also known as lying under oath, that's a one-way ticket to jail. An example of this is that very shortly after a judgment is entered against you, creditors have the legal right to demand information about your assets that you own, and the courts enforce this right very broadly. So at this point in litigation, the only way to keep an asset anonymous or a secret is to lie about them and commit perjury. We don't advocate for hiding. We prefer just to have full disclosures of a proper asset protection plan and just set it up properly to work. So for assets that are real estate, we recommend using the state that the real estate is located in, because again, you're not gaining anything by using another state. You're just doubling your maintenance costs. So just keep it simple, and then you add layers to that protection system as you grow. Just remember, the weakness with LLCs is that it's still just maybe protection and used more as a deterrent. Maybe it will be upheld, maybe not. Maybe the judge will pierce the veil, maybe not. There's a lot of uncertainty, and that's not good, especially when strength and power is important. The second tool is the asset management limited partnership. So now we're going up in a layer. Asset management limited partners, the AMLP. This layer comes into play around $450,000 to $700,000 of unprotected net worth. And generally at this point, you have about 4 different properties and possibly investing in multiple states, along with some personal stocks and brokerage accounts, maybe some crypto. It's similar to an LLC in that it has a layer of protection around it to limit your liability. And they have some charging order protection and built-in statutory privacy. And one thing I want to mention real quick is I said crypto. You need to realize your cryptocurrency, even though it's digital currency, is defined by the IRS as a property. And the exchanges can be subpoenaed. And if you are in court and you're given an asset disclosure list, you're going to have to disclose your assets. That includes your crypto. And if you don't, and you lie under oath and say you don't have any, you just, again, committed perjury. So we need to protect your crypto digital currencies and assign those out of your own personal name, like move the wallets out of your name, move your tokens out of your name, move your exchanges out of your personal name, and assign them into the asset protection plan that you create. And you would move those into this layer right here. This mid layer is your holding company. And it's this mid layer where you actually do want to use one of those states, that are really good, offer really good protection around the LLCs, like Arizona, Nevada, Wyoming, or Delaware. This mid layer protection should be a multi-member limited entity, whereas the base layer LLCs that we just talked about, they can be a single member LLC, because remember, at that base level layer, that single member LLC gets disregarded for tax purposes. But as you stage and grow your protection, you want it disregarded for tax purposes, because when a client comes to me with 15 pieces of real estate and 10 different LLCs, we don't want that client to have 10 separate tax returns, 10 separate K1s. So by making those base layer LLCs single member LLCs, it helps with tax filings when we add the mid layer AMLP, because all those K1s flow directly through into that management company. But the AMLP is a step up from an LLC, since it also works very well as an asset holding company, because it has 2 different classes of ownership that an LLC just does not have. So limited partnerships have a general partnership interest and a limited partnership interest. The general partner is the controlling interest, and it's typically you, the client, you and your spouse, which gives you control of your assets to, keep investing as the managing members. And the limited minority partnership is your asset protection bridge trust. And that's actually the ownership interest of the limited partnerships. By dividing it up like this, you get a separation of ownership and control. And remember, asset protection is about separation, strength, and power. You just can't get this with an LLC. But unfortunately, I see this a lot with clients having the second layer of protection being another LLC or a Wyoming LLC and not a limited partnership. And so when they come to us, we have to clean this up. So we use an Arizona limited partnership as the starting point for clients as that mid layer, that second layer holding company, and then add the bridge trust to it for the actual strong asset protection component for that third layer. One of the main reasons we use Arizona for the limited partnership is because of ARS section 29-333. This section specifically allows for a limited partnership to make what's called a unilateral withdrawal from the limited partnership upon the occurrence of a predefined event like a lawsuit. And this is specifically unique to Arizona and becomes very handy when we connect the third layer asset protection trust to that limited partnership, because it allows the trust to disconnect from the holding company during that time of duress or that doomsday lawsuit, demand the assets and make that unilateral withdrawal. This cannot be done with an LLC. And I want to spend a little bit more time here talking about, the mid-layer AMLP and why specifically in Arizona limited partnership. Beyond the distinction between the managing partner and the minority partner, some of the other specific reasons I prefer an Arizona limited partnership, over Wyoming LLC or others are you have exclusive charging order protection in Arizona as the only remedy for creditors of a partnership. You have an actual statutory distinction between general partners and limited partners by statute. This is better than LLCs because LLCs can only do this by an operating agreement that a court then will have to interpret. So now you're left at a judicial interpretation by a judge. Again, we have ARS section 29-333, which specifically allows for a limited partner to make a unilateral withdrawal and disconnect from the holding company during that lawsuit. This just cannot be done at all with an LLC without exposing you to a claim of fraudulent transfer. And so this is already building a really good list, but just a few others are the Arizona limited partnership is perpetual, whereas every other states have an annual report and filing for LLCs. Arizona does not require listing the limited partnership. You only need to list the general partners. So by their nature, the limited partners are already completely private. And then for tax filing purposes, your limited partnerships cannot be a disregarded entity, but LLCs with just one member are automatically considered a disregarded entity. And remember, being disregarded is not good for liability issues and lawsuits. And so the way the limited partnership works is that all the LLCs that you create, to hold your risky assets like real estate are owned by the limited partnership, along with, we can put passively directly into the limited partnership, cash, stocks, bonds, receivables, syndication shares, whatever safe assets you have. We would assign your crypto into that again. The way ownership and control gets set up is that the general partner of the limited partnership, which can be you or a Wyoming LLC if you really were obsessed about, creating some privacy, additional privacy, is the managing partner. And that now gives you control and privacy. The minority limited partner is the bridge trust, the asset protection trust. And that's where the asset protection component really connects and kicks in. That's why I like the AMLP or the asset management limited partnership, over an LLC at this mid-layer, second layer Carnegie level. You just have so many additional protection mechanisms statutorily built into them. But it's really is the combination of the two working together, the AMLP and the bridge trust, that you really want to capitalize on. And so this brings, me to the third tool or third layer, which is the outer shell, bad weather layer. It's the dead of winter. We're in the frozen tundra or Siberia, and it's the asset protection trust. And it's really the heart and soul of the system. At this point, you have multiple assets, and your net worth is generally around, 1 to 1.2 million of unprotected assets or more. And you possibly have a high-risk profession like a doctor, dentist, lawyer, CPA, entrepreneur, or now you're either a full-time real estate investor or about to transition into full-time real estate investing. We call this the bridge trust since it's easier to relate the concepts to. When you're attacked with a lawsuit, we cross the bridge to the safety of the Cook Islands and break the bridge. But before we talk about the bridge trust, I want to talk about asset protection trust in general. And what I want to start with is just like really the essential basic is just what is an asset protection trust. And I really want to spend time with this, because after this, I guarantee you're going to know more than 99% of attorneys out there about asset protection trust. And so what is an asset protection trust? An asset protection trust is what is called a self-settled spendthrift trust. So all self-settled means is that you are creating it for yourself, not for your kids or your grandkids. It's not Uncle Buck creating it for Orphan Annie. It's you creating it for yourself. So they are for you, by you, as your own beneficiary. And they have the very important spendthrift provisions in them. And you are probably somewhat familiar with another type of self-settled spendthrift trust called a revocable living trust. Many of you have heard of them or your family members have them, parents, grandparents, aunts, uncles. They are the same in that they are self-settled, meaning created for you, by you. The difference is that with an asset protection version of this trust, it includes these critical provisions called spendthrift provisions. And what spendthrift provisions are is that they are provisions that allow you to protect your assets from creditors. They are the actual teeth behind it. And for these to work, the trust has to be not revocable, but irrevocable. So it is actually a very different type of trust. And so now there are two major schools of thoughts. There's the international and the domestic. You can set them up here in the US or offshore. Now I'm going to talk about them both and through a historical context. And it's very important if you are going to be understanding how the trust work and why the British trust works, to understand the two basic components. The international trust came first. It was created in 1984 in the famous Cook Islands. So that was like 36 years ago. So it has quite a bit of history and a lot of case law. I like and choose the Cook Islands if and when it's applicable, just because it offers the best home court advantage. Why it is the best home court advantage is because asset protection is what these trusts and the Cook Island statutes were specifically drafted for. They are the global gold standard of the world, even today. And the greatness of the Cook Islands is that it starts with the statutory non-recognition of any other jurisdiction's court orders in the world, including the United States. What this means is that if you have a judgment against you in the United States and they took it down to the Cook Islands, your judgment is worthless. It literally has no value whatsoever. Statutorily, the Cook Islands is prohibited from even recognizing it. If somebody wants to sue your trust in the Cook Islands, they would have to start their case all over from scratch. The person suing you would have to prove their case beyond a reasonable doubt. That's the murder standard, the highest legal standard in the world, the 99% sure standard. That is incredibly difficult to meet. In the US, just for a civil case, it's just a 51% standard called a preponderance of the evidence. That's the, yeah, I think more likely than not, that's what happened. I don't know, but that's kind of like the route I'm going. But beyond a reasonable doubt standard is just incredibly difficult to meet. You can't get a contingency fee attorney to represent you because they're not allowed down there. It's unethical on the Cook Islands, just like it used to be unethical here in the United States. But that got changed in the 60s because lawyers realized that if they can't get part of the action, it's hard to get lawsuits going. The claim, meaning the lawsuit, is not amendable, meaning that once you file your complaint, that's it. You can't change it or amend it after discovery like you can in the United States. It's common practice in the US to file a lawsuit and then get into the discovery, start digging things up, and then amend your complaint and go, oh, but we found a different thing and we didn't even know about this thing. So now we're going to be changing our mind about what we're even suing you about. That's not allowed in the Cook Islands. You can't amend your complaint and your claims. The person suing you will also have to front the entire court cost and find a judge from New Zealand. And if you lose, you pay. And this is one of the single worst things that we don't have in the United States, that the loser does not need to pay the legal fees and the cost of the winner. So if you get sued by somebody for just a completely bogus reason, just a complete frivolous lawsuit, and you spend $200,000 or more defending yourself in legal fees, and then finally the court throws that lawsuit out, you're still out $200,000. That person that sued you is not going to be getting the bill for that, because in our legal system in the United States, that would discourage lawsuits. And our legal system is run by trial lawyers who don't want to discourage lawsuits. So we don't have that system. But the Cook Islands, they do have that system. And then with the burden of proof beyond a reasonable doubt, whoever's attacking you almost certainly is going to lose. And so they will be paying your legal fees also. And so this is just a disincentive that's massive to try to sue you there. And not to mention that the statute of limitations is short. It's going to be most likely already run since it's only 1 year. Basically, before they even take a shot at suing you in the Cook Islands and realize that a Cook Islands trust is involved and in play, they miss their chance. They're going to be completely barred from even following their lawsuit down there. And in practicing, law and even taking into account all of our affiliates, all of our law firms, associations, and all of the lawyers that we have working with us and dealing with thousands of these trusts over decades, we have had a sum total of zero. I mean, literally zero plaintiffs that have followed any of our clients down to the Cook Islands. It's just too daunting of a task. It's not something anybody has ever been successful at doing, and you would have to just pay a lot of upfront costs just to then go ahead and lose. And so let's start out. What are the advantages of the international option? And so the Foreign Asset Protection Trust, again, has been around for over 36 years with a very strong case history of how they work and are upheld, even against the government super creditors like the IRS and the SEC, and then supporting case law all the way up through the Supreme Court. What we see with the foreign case law is that even in the worst of the worst cases, the assets are still safe. And then the offshore trust forces a settlement literally for pennies on the dollar, even against the government, who are generally the only people who can actually go and fight you there, and they still lose. Now, comparing this to the four things a client wants, remember that four-part test, remember ECCC? I mean, number one, effectiveness. I mean, the Foreign Asset Protection Trust gets 5 out of 5 stars. I mean, statutory non-recognition. No other asset protection trust is going to be stronger in the world. I don't know a single person that would ever argue against that. And a fully offshore Cook Islands Asset Protection Trust specifically is as strong as it comes. But what about the drawbacks? What about the other 3 tests, control costs and compliance, / maintenance? On these, it falls short. This is the fully Foreign Asset Protection Trust kryptonite. The costs, they're going to be high. It's going to be expensive just to set up a purely Foreign Asset Protection Trust. Generally about $35,000 to $75,000 range. And from $5,000 up to $10,000 annually just to maintain. We'll tell clients to budget $10,000 annually just to maintain a fully Foreign Asset Protection Trust. Setting up a fully Foreign Asset Protection Trust is not a small task. And if you are purely a foreign trust, you now have a lot more IRS reporting compliance and disclosures to file every year. You have to file the IRS forms 3520 and 3520As, which is a full balance sheet disclosure of all the trust assets and disclose all the trust roles. And even in some cases, even the entire trust agreement with the IRS. And that form is not cheap from a CPA standpoint. And it's not something most clients would be very excited about providing to the IRS. If the assets are moved offshore, because you have an offshore trust, which we would recommend if you're going to go through all of this trouble to putting a fully, asset protection trust together, you probably need to put, the assets offshore as well. So then you're going to have additional compliance called FATCA account tax compliance. And of course, you're not going to be in control of that trust. It does not work if you are in control of it. For a foreign asset protection trust to work, you must be out of control and subject to a foreign trustee or the foreign trust company down in the Cook Islands. That's why they work so well. And, just so many clients are not comfortable with that. They're not familiar or comfortable with offshore banking. So the drawbacks are, if we go back to our 4-part test, control. No, you're not going to be in control of that trust. Cost, not very reasonable. It's pretty expensive. Compliance and maintenance. You have a lot of compliance and maintenance fees and disclosures. So while we have the most effective trusts in the world by far, it's not something that we usually are starting out with because of the fact that we have all these drawbacks. And so, excuse me, I have some case law here. We have the famous seminal Anderson case. I'm going to just briefly flash through these on the screen, and feel free to look them up. I also have the cases in my legal library on my website. The clients in the Anderson case were criminals, and the trust assets were made up of ill-gotten gains from a Ponzi marketing scheme. And the clients remained as the trust protectors also while they were in front of the U.S. judge, which was really, not what you want to do. We would not be setting our clients up as also the trust protectors. That should be your attorney, because otherwise you're just weakening the plan at that point. But what were the results here? 90% of the assets were protected. They were able to force a settlement for literally pennies on the dollar. And these cases I'm using are fully foreign asset protection trust cases, and they represent literally the worst case scenarios of the use and misuse of the international trust. In each case, the trust was flawed in one way or the other, just like we were talking about here with the Anderson staying as a trust protector. But in each case, the trust upheld and did its job. and the assets were protected and safe. Okay, then we got the Grant case. This is an IRS case, with a $36 million IRS debt, and the assets were still protected. So even the IRS were not able to break the trust. So 100% of the assets here were protected. Then we got the Slow case, an SEC case, so another super creditor government case. And again, the assets were protected. And so these were the worst cases that we could really even find. And even in these bad cases, the Foreign Asset Protection Trust, and in particular, the Cook Islands Trust, was able to protect the assets. And again, that just goes to the effectiveness of the trust. Which brings us now to the other option, the domestic trust. So let's talk about the domestic side. The Domestic Asset Protection Trust came around later, after the offshore ones, about 10 years later in 1998. So they're newer with less case law. The first state, in the US to pass the domestic option was Alaska, of all places. The theory was, why are we sending all this money to the Cook Islands and other jurisdictions around the world? Why don't we just do it here? We've been doing it for years in Nevada and Wyoming for asset protection. Why not just create our own asset protection trust statutes? And so Alaska did. And, on a side note, we actually know the person who drafted that first statute. And, that person was a professor of my partner at NYU. And so, and not to be left out, now over 19 US states have passed domestic self-settled spendthrift legislation in one way or another. We got Delaware, Wyoming, Nevada, and others. And their motivation was, why do we want to be sending business to Alaska? We're already the states known for all of this. So, we want in on the action also. So the states are jumping on board, seeing that our legal system is now a threat, and then things that, need to get done to protect your assets. And so asset protection in the United States is very valid, especially in these states and also federally. Lots of federal protections already exist through, other plans like ERISA protection plans from 401ks and IRAs and other exempt asset classes. So asset protection as a concept is very important for you to understand is valid. How you do it is really where it gets important. The issue with purely domestic asset protection trusts is that the domestic asset protection trusts are really only created for the benefit of the residents of those states. And we now have problems of non-residents using other states' asset protection trusts, like California residents who don't recognize asset protection trusts and have no self-settled spendthrift legislation of their own, running off to Nevada and creating a Nevada asset protection trust. Well, the court stopped that in 2012 in California with a case called Kilker v. Steelman. Here they told a California resident they're no longer recognizing out-of-state asset protection trust, and this was upheld by the Court of Appeals. And the advantages, let's go over what are the advantages of the purely domestic asset protection trust. They were really popular in the early 2000s because a lot of people said, well, why go offshore? It's less expensive and, it's easier domestically. So what are the advantages? Well, cost, the cost of a purely domestic asset protection trust is lower since it's not a foreign trust. A lot of domestic attorneys said that they were never really comfortable offshore because they felt very comfortable, doing a Nevada trust where I have a trust company who gave me a boilerplate language and told me how to do it. And then I went to a seminar, a continuing legal education seminar, and learned. So these trusts can be, as little as $10,000 to set up. And then the compliance is less since it's not a foreign trust. You have less mandatory IRS reporting requirements and disclosures. And you also don't have the same compliance because, these are not foreign trusts. So much of that compliance that we were talking about was related to a purely foreign asset protection trust. So Form 3520 and 3528 are not required. FACTA is not required because we have no foreign accounts. So that's great. That's the good side. But what are the disadvantages? Well, on the negative side, unfortunately, you lose on effectiveness of all things. We live in the United States of America. We have a constitution. First, the purely domestic asset protection trust has been around for half the time as the foreign asset protection trust. And so we have seen rulings domestically taking down high-profile domestic asset protection trusts. Courts are simply ignoring the choice of law clause. And courts are even ignoring them now in states that recognize asset protection trusts and even have self-settled spendthrift legislations. the legal landscape again is shifting. And failure means breach and assets lost. This is just unacceptable. And all you really had was a false sense of security. They failed because of the foundation of asset protection. The foundation is not recognizing another jurisdiction's orders. Yet, like I mentioned before, the foundation of the US legal system is the US Constitution. The US Constitution in Article 4, Section 1 provides that every state must grant full faith and credit to judicial proceedings of every other state. This means that, for example, Nevada can pass an asset protection statute, but it cannot ignore a California or Washington or Florida court order. So where the court, the Cook Islands can just literally throw that California judgment in the trash, Nevada cannot. Nevada must respect it constitutionally and even litigate it. So on this front, the purely domestic asset protection trust is very different from a foreign trust. Also, they fail on control. On the control front, they're weak, since you must make sure to give up control of your domestic trust to a trustee for that trust even to carry any strength. And as I mentioned, a few times we're now seeing a pattern of case law, that are weakening purely domestic asset protection trusts. We now have case law coming around. They started coming around in 2006, 2007, 2009. And what we find is that these purely domestic asset protection trusts fail, and they have not been very effective at all. We have, what the case is Bately versus Mortensen. That's right. This is an Alaskan resident case who created, who created an Alaska domestic asset protection trust. The courts used a 10-year clawback provision to include his domestic asset protection trust assets. And the result was a complete trust failure and loss of his assets. And we got In re Hubbard, same thing. This case, complete trust failure. Next case, Kilker versus Steelman. This was that California resident case I mentioned using a Nevada domestic asset protection trust. And the courts used a 10-year look back period, as well as literally created a new legal standard called a reasonable foreseeable creditor. That never existed before. And they also ignored the choice of law clause, resulting in complete failure and loss of assets. Next one, we got Dale versus Dale. Same thing. A Utah court completely ignored the Nevada choice of law provision, applied Utah law on public policy reasons, and again resulted in total failure of the trust and full loss of assets. And so these cases show what's now a trend of failed purely domestic asset protection trust. These cases, except for Hubbard, they all had good facts and they still failed. And failure in asset protection is not good. Failure, again, means loss of assets. The challenges are we have the full faith and credit clause, the choice of law issues, meaning which law is the judge going to even apply? Just like I mentioned before, when you think that you're doing yourself a favor by having a Wyoming LLC to hold a piece of California real estate, to then find out California law is going to be applied anyways. The same thing is happening in the trust world now. Bankruptcy has addressed self-settled trust and established a 10-year look-back period. Even in those 19 domestic asset protection trust states, they created exceptions to what those trusts can even protect. And then judges have just now found ways around them. So with the recent trend in cases pointing towards all this new doctrine, along with the fraudulent transfer rules, all this is affecting asset protection planning and even the states recognizing self-settled spendthrift trust. The modern transition of asset protection now is to transition away from older methods of asset protection towards more modern cutting-edge techniques so that we can enable lawyers to offer a broader spectrum of solutions to secure your assets from this out-of-control system. And though you had a lot of excitement in the early 2000s about the domestic asset protection trust, I don't think you have them that much anymore. I don't know very many attorneys that still use just a purely domestic asset protection trust. And if they do, generally it's only used sparingly and for clients that live in the state that has a statute. Just like you wouldn't want to use a series LLC unless you're in a state that has a series LLC statute. The same is true for a domestic asset protection trust, and still only sparingly. And maybe just because there's a better solution now that exists. Just to quickly touch upon this, the Avoidable Transfer Act became effective in California on January 1st, 2016, just an FYI. So now we see the lay of the land. And the landscape, and you know what the lay of the land is, the landscape, and the pros and cons of LLCs and both offshore and domestic trust, and what we're actually up against now to protect your assets. So what do we do? Right? Begs the question, like seems like it's a complete mess, right? This is where we get to a better solution now. This is where we get into the hybrid options. Just like hybrid cars, you get really good advantages when you take the good out of each. If you are our clients, you have the benefit of the best of both worlds, called the bridge trust. It's the premier version of a foreign domestic hybrid trust. My affiliate Douglas is considered the creator of the hybrid trust over 28 years ago. The bridge trust is both domestic and foreign. It's a hybrid. It combines the best of both. It's a foreign offshore Cook Islands trust. So it is actually a foreign trust drafted as a foreign asset protection trust. It's registered offshore, in an offshore jurisdiction in the Cook Islands from the day it's created. And then for the purpose of IRS compliance, it's bridged back into the United States. Its foundation is strongly planted domestically, also from its creation, to meeting a two-part test called the court test and the control test under USC section 7701. This allows it to be treated as a domestic trust for tax purposes. So it's like having two passports. You can have a Swiss passport and a US passport. And as long as you have your US passport, the US will consider you as a US resident. And it doesn't care that you also have a Swiss passport. The same thing is true with trust. As long as you meet this two-part test, the control test and the court test under 7701, the US says this is a domestic trust. So as long as you have a US jurisdiction that has primary supervision over the trust, we meet the court test. As long as there's a US person with primary control over the trust, we meet the control test. So how do we do this? Well, we recite a US jurisdiction for the trust. Which one we use will all depend on where you live. If you live in one of those 19 states that have a domestic asset protection trust statute, then we'll use that state. If not, we're going to use Nevada. And that's just because of all those states that have domestic asset protection trust statutes, Nevada's the best. But we'll just recite it, but we are not going to take all the effort to be a full, Nevada asset protection trust, because that is not the goal of the bridge trust. Remember, the bridge trust is a foreign asset protection trust. We are only using Nevada as a jurisdiction to meet that two-part test under 7701. What we want is to have the option to be offshore if and when we ever want to need that power, and the flexibility of being classified as a domestic trust for IRS purposes. If we have no event of crisis, or pre-duress, meaning before a lawsuit occurs, so everything's nice and peaceful and calm, the trust is treated as a simple domestic grantor's trust, just like a revocable living trust. It is literally disregarded for tax purposes. This means no IRS forms 3520As, no IRS FACTA disclosures. Your assets can remain in your own domestic bank. You have no need for an active foreign trustee. You remain as the trustee, and this gives you control, unless it's critical to give it away, like post duress. And your trust is a tax neutral domestic trust, and your maintenance cost is lower. Now, post duress, what happens post duress? Now what happens during a lawsuit? The trust protector, which would be your attorney or law firm, you would want your attorney serving as the trust protector because you want attorney-client privilege. So we would serve as your trust protector. We would declare an event of duress, which would cause a few things to happen. One, the offshore trustee that we said was on standby is no longer in standby. They become a co-trustee with you. And two, they now have the power to remove you as the trustee because you're now in the jurisdiction where the event of duress has occurred. And since you are there, you are now vulnerable to the court. So we don't want you in control of the trust at that point. At that point, the offshore trustee can take whatever steps are appropriate to protect the assets, that are in the trust. This can then include, opening up an account in Switzerland, Luxembourg, Uzbekistan, or any other valid jurisdiction. It can include leveraging assets, stripping the equity, selling the assets. We're going to take whatever steps are appropriate based on the situation and based on the level of the threat and the lawsuit that's providing to protect the assets. And if you are an affluent family and can set aside 1 million or more, of 1 million or more of US dollars in a foreign Swiss bank, we would just suggest setting up the foreign bank account early, when the trust is created, so that you can take advantage of jurisdictional global diversification investing, which provides more prudent exposure to financial markets and investment opportunities that are reserved for the Swiss and European banks. But you would need stage 1 of the planning in place first, which is the trust, before you even move on to stage 2. So the bridge trust is just incredibly effective, and it hits all the needs that you're looking for. Remember that 4-part test, ECCC. Is it effective? Yeah, it's a foreign asset protection trust. It is actually a Cook Islands trust. 2, control. Yes, you will be in control of your trust right up until the last second where it is appropriate, that it's, in your interest to be in control. Otherwise, then we will remove control. 3, cost. It's much more reasonable. It's still an investment on your part, but it is not $50,000, and $10,000 a year to maintain. And maintenance and compliance. There is none. As long as, you're not triggering the trust, there is no compliance whatsoever because it is classified by the IRS domestically. So if you do have to trigger the trust and you do go to the full foreign asset protection trust, then you will have the compliance. But remember, at that point, you want it. You are willing to pay for it because the benefit of the effectiveness is now the most important thing to you. Okay, so this is a spot, good spot to recap all of this, and I'm going to put it all together with this graphic because I just think it helps. And so if we go back over the tools we have the asset management limited partnership. You really want to think about this as your holding company in the center of your structure. It's going to be attached to these little houses down here, which are your LLCs. This is your base layer. It holds your risky assets, real estate, properties, boats, planes. Then you have your bridge trust on the top right. And, we're still going to use a revocable living trust because, it's your estate plan. So these are your components laid out here. The LLCs are single members to the extent that we can make them. This eliminates a tax return and makes the accounting easy. They're connected and held in the holding company. Other assets that the holding company can hold directly are, cash, stocks, bonds, cryptocurrencies, anything that's already safe and can't hurt somebody else. It's not risky. There's no key, no motor, no door. You don't need to purchase liability insurance for it. Who controls that AMLP is you, you and your spouse. You either control directly or, through an LLC. If you want an additional layer of privacy, who owns that AMLP is the bridge trust. And that's the key. The bridge trust is actually the majority owner of that AMLP. So the bridge trust actually owns all the assets. Remember, we're separating control, which is beneficial use and enjoyment, from ownership and liability. At this point, one of two things will happen. Either you die and everything passes through your revocable living trust. It's very smooth. Your estate gets distributed. You maximize your estate exemptions. You avoid probate, smoothly pass your assets. You can maximize your, maximize your tax exemptions. Or the other option is you have some type of crisis, doomsday event. At this point, under section 29-333, the assets merge into the bridge trust. The bridge trust demands a unilateral withdrawal, and poof, the assets are moved to wherever the trustee deems at that point the assets are going to be most appropriately protected. And so, if some of you need to duck out, this would be a good point. My contact info is in the chat, and you can just email me at brian@btblegal.com. I have some case studies here that I'm going to now briefly go over, to see real life application and just where the assets are placed. Here we have some good examples of the bridge trust in effect. We have John and Jane, both doctors. Jane has her own practice and John works for a large hospital. They have combined income of over $600,000 annually and the following assets: a home in California. Home has a mortgage on it. Still have some equity in there. That's going to go directly into the bridge trust. And you put your personal residence into the bridge trust, not into an LLC, because we don't want to lose the tax credits and benefits of home ownership, but we still want to protect your home. So that's going to go directly into the bridge trust. Jane's office building here, that's going to go into his own LLC. They have some rental property. That rental property is going to go into LLCs in the state that they're at. Personal brokerage accounts will be assigned into the limited partnership. Syndications that are passive are going to go directly into that limited partnership. Cryptocurrency. Remember, cryptocurrency is defined by the IRS as a property. So that means that we have to protect it. So we would assign your cryptocurrencies and tokens, wallets, and exchanges into the limited partnership. Cars, your personal car, it's just all risk. There's no investment out of that. So we just keep them out. Retirement plans, 401ks and IRAs, those are already protected and exempted, like ERISA protected. So we're going to leave those out. Case study number 2, Sarah. Sarah is an entrepreneur and has an online business which grosses $3 million annually, and that's over $500,000 annually and growing. So she is really on her way. She's considering getting married and has the following assets: a home in Georgia. That home is going to go directly into the bridge trust. A warehouse for products. All right, that warehouse is going to go into its own LLC. She has a second home, her parents' home that the parents are living in. That's going to go into an LLC because it's not her primary, but we still want to protect it from lawsuits of her life and if anything happens, through the property. So that's going to go into an LLC. Brokerage accounts, again, go directly into the limited partnership. Cryptocurrencies, again, need to be protected. They're going to go into the limited partnership. Cars, depends on, like, if it's a luxury car, not a luxury car, but a vintage old school car, 1969 Jags, or cars that are going to appreciate in value, you can always put them into an LLC, but generally I would just say leave them in your personal name. Again, we already know retirement plans, 401ks and IRAs are exempted. Case study number 3, Will and Judy. Will owns his own business and Judy has raised the family. The kids are grown and the last one is now in college. Will is considered, he's concerned with passing his estate and asset protection and considering a sale of his business. Judy's thinking of starting a business now that the kids are out of the home. They have the following assets: a home in Texas. Texas has some homestead protection exemption, but it's not 100% like Florida. So we would still put that home in Texas directly into the bridge trust. The big thing here with them is that there's no mortgage on there anymore. So that value of that home, that's 2.2 million, is straight in equity. That's a lot of money out there for someone to sue and to come after. And so we need to protect that for sure. Office building valued at 4 million with $2 million mortgage, so 2 million in in equity. Got to protect that. That's going to go directly into the LLC. But we don't want the office equipment owned by that. The office equipment is going to be owned in its own LLC. So they have 1.5 million worth of office equipment. It's a lot of office equipment. So we need to get that out of the office building LLC and into its own asset LLC for the office equipment. They have an investment property of a mini storage valued at 15 million with a $4.5 million mortgage still on there. A lot of equity and a lot of liability. So we need to definitely put that mini storage into its own LLC. Brokerage accounts, we already know we assign those to the limited partnership. Cryptocurrency, it does exist. It is a property classified by the IRS. It can be forced to subject to lawsuits and judgments. So we need to assign those into the limited partnership. Retirement plans, again, they're protected exempt assets. The value of the business, this we could place directly into the limited partnership or the bridge trust. We would just do an assessment. Mr. Real Estate. So what happens here? I like these what happened really. So here's Mr. Real Estate. He had over 150 million in real estate in 2008 with over 50 million in equity. He had a Cook Islands Asset Protection Trust, so a very strong trust, with 2 domestic holding companies in the form of limited partnerships. In August of 2009, 80% of his portfolio was underwater. The remaining 20% was still encumbered by banks. So, and there was some cash. What happens to Mr. Real Estate? The result here, we were able to protect 10 million in cash offshore in the Cook Islands, and 80% of the remaining real estate equity he had that was available to, was retained. Mr. Nice Brother. These one, I get these ones a lot. This is basically like a personal guarantee that You can replace the word Mr. Nice Brother with Mr. Nice Dad, or Miss Nice Mom, or Mr. Nice Uncle. But Mr. Nice Brother was a dentist and was talking. He was talked into signing on a bond for his brother, who was building a large real estate development. He has $5 million in assets, all of which were in the asset management limited partnership and the bridge trust structure. So he had the AMLP and this very strong bridge trust. His brother's development doesn't work out, and the bond paid out $17 million, which they sought to recover from my client, Mr. Nice Brother. So just think of it also as like a personal guarantee that you give to your kids or your brother or your sister. Generally, those deals fall apart. You're left on the hook. So what happens to Mr. Nice Brother? The results: settled for $125,000. Not bad, right? Mr. California. What happens to Mr. California? Mr. California owned a thriving medical practice with 27 employees and was also an avid real estate investor, as most doctors are. So he accumulated over 10 million in real estate when he realized that he had a staph infection, but not the type of staph infection that we're thinking of. One of his longtime employees was made aware of a California wage and hour rule and realized that Mr. California hadn't been tracking breaks just quite right. I actually used to do a lot of wage and hour claim law when I started out. So this reminisces me back to my starting days of trial law. Her and her new best friends, the employment lawyer, filed a lawsuit alleging overtime and attempting to attract other employees to create a class action lawsuit. Exactly, because that's what these wage and hour claims are for. Potential damages were over 1 million potentially in damage awards. $1 million this person is on the hook potentially for. What happened to Mr. California? The results: settled for $5,000 to the original employee only. That's a big benefit. So this is a good point, to offer, see if you have any questions. I think, for the most part, a lot of them were answered during the presentation. This is a really good slide that I like to use to, visually see again how this all works out with the LLCs down there at the bottom layer, filtering up into the limited partnership. And then that limited partnership can also hold like cash, stocks, bonds, receivables, passive syndication shares. And then, you're going to be the 1% owner. You and your spouse will each own 1% of that limited partnership. The bridge trust is going to own 98% of that limited partnership. And then you got your revocable living trust down there, which just connects to the bridge trust by us referencing it in its name. And so, I hope all this makes sense and clears up a lot of your questions. I think I just covered, like 4 hours worth of material in about, an hour and 12 hour and 15 minutes. So I know I threw a lot out at you. So here's my invitation. Whatever stage you're at, if you're at the beginning stages and just buying literally like your first property, that's great. That's fine. If you have, 1 million, 4 million, or 100 million worth of properties and just not sure if you have it all set up correctly, either way, I invite you to call and email, call me or email and schedule an appointment, and I'll go over your situation and give you a recommendation. Again, just reach out to me via email, Brian, BRIAN at btblegal.com, or my website, www.btblegal.com. Again, thank you very much. And I hope that, this presentation was very informative and helpful. And, again, we're here to help, and I hope wish you the best in your financial lives. Thanks.